I'm Louisa. I am a senior counsel here at Taylor Wessing in the competition team, and I'm just going to talk to you very briefly. I have got 18 minutes left, so I will talk to you very, very briefly about competition law and just give you an update on what has been happening over the last year in the world of competition law in relation to pharma. So what I'm going to talk about is there's been the resolution of two ongoing EU pharma investigations. Finally, Lundbeck has drawn to a conclusion, and also Aspen and its excessive pricing case. And that investigation has ended in a settlement decision. And also I'm going to touch briefly on merger control and how the Commission is going to deal with killer acquisitions, which affect pharma, the pharma sector, and also tech, but obviously we're just interested in pharma here. I'm sure that you're all very well aware of the competition issues that might arise in the context of pharma, but I've just set out some here so that you can have a so you can just see what they are mainly in front of you. I think pharma has a particular focus with competition regulators, largely because of the type of products that are involved, and also the patent situation, where, as you know, patent holders are given a legal monopoly over the products that they have created and have ploughed a lot of money into. So obviously they want to charge high prices in order to recoup some of the R&D. And as a result, really, of the patent situation, the markets do tend to be pretty contentious. You know, with genetic companies entering at risk, possibly infringing the patents that are there, and that leads to agreements between competitors and potential competitors. And as I'm sure you know, agreements between competitors can lead to concerns. For example, in a general context, agreements between competitors, there can be exchange of competitively sensitive information, which will draw a great deal of regulator scrutiny. The main round of investigations over the past decade in the EU have really focused on settlement agreements and so-called pay-for-delay agreements. And these agreements are where originator companies pay generic manufacturers huge sums of money or other types of value in order for them not to enter the market. I think we are reaching the conclusion of a number of those investigations that have been on for a while. And there has been a more recent focus on excessive pricing, which is notoriously complex, but nonetheless, the Commission is dipping its toe into that area. So let's talk quickly about Lundbeck. Now, this case has been trundling on for quite some time, and it's finally drawn to a conclusion. Just to give you a brief background of this, in 2002, Lundbeck, which manufactured citalopram, entered into a number of agreements with some generic manufacturers. The terms of the agreements were that the generics were given either large sums of money or other transfers of value in exchange for not entering the market at the end of the patent. So the other transfers of value included that Lundbeck would buy their stock of the generic medicines, and they also offered guaranteed profits in the form of a distribution agreement where the generic manufacturers would distribute citalopram on behalf of Lundbeck throughout the EU. So the Commission opened an investigation in 2009 or 2010, and in 2013 it issued its decision that these agreements were illegal, and they fined Lundbeck 93 million euros, and all the other parties were fined a total of 146 million euros. The Commission found that the generic manufacturers and Lundbeck were potential competitors, so it was a horizontal agreement not to compete with each other. It was market sharing. There had been significant value in exchange for non-market entry by the generics, and the value that was transferred was far in excess of any profits that would have been achieved by the generics when they sold their own products. And ultimately, what they said was that the agreements that Lundbeck had reached with the generic manufacturers had gone further than the protection that they would otherwise have been afforded under the terms of the patent. So all the parties appealed, and in 2016, the General Court dismissed it and basically said that the agreements were market sharing. So 5 years on from the General Court, the European Court of Justice issued its judgment in 2021, and it confirmed what we all suspected, what we all knew. There was no surprises here, but they said that the pay for delay agreements are by object infringements, which means that they're automatic infringements of competition law. We don't need to consider the effects of them. It is just a pure infringement. And as part of that, I should say that, as I'm sure you know, settlement agreements are by and large absolutely fine, and they are not infringements of competition law. But the pay for delay in particular are infringements of competition law because they include a transfer of value, and that transfer of value cannot be justified under any in any way, essentially. And it's that transfer of value in exchange for agreeing not to compete that has taken it into legal grounds. The Commission has also, not the Commission, sorry, the General Court, the Court of Justice, sorry, has it reaffirmed its position in relation to potential competitors. And essentially, to be a potential competitor, there has to be real and concrete possibilities for the generic to enter the market. And in line with that, the existence of a patent is not seen to be an insurmountable barrier to entry. So when they're considering whether or not a party should or could have entered the market, the Commission will not look at the strength of the patent. They won't perform any analysis of the generic entering at risk. It'll just be, they will just look at it and say, doesn't matter, the patent's there, they could or should have entered. Here we are. So moving on from pay for delay, we have the recent commitments decision in Aspen, which related to excessive pricing, which is a notoriously complex area that the Commission doesn't usually dip its toe into. But here we are, we have a decision that we can look at. So, I mean, it's quite clear from the fact that there was some excessive pricing going on. Aspen had bought in 2012 6 off-patent cancer medicines, and from 2012 onwards, it increased the price of these products by several 100% across Europe. And in 2017, the Commission opened a formal investigation into the behaviour, and ultimately Aspen sought to settle the case and bring it to a close, which it has done. Now, the Commission's case was that the price increases were not justified. they were unfair. The unit cost increases for the product were between 10 and 40%, but the price increases for the products were between 180 and 430%. So there's no correlation between the two, and ultimately the price increases were hugely disproportionate and without legitimate reason. Also, Aspen hadn't improved its products in any way. There was no R&D. They hadn't spent anything other than purchasing the products. And there was a clear strategy to exploit the health services across the EU. Also, the final point, the Commission found internal documentations from Aspen that proved that their strategy was to increase the prices because they threatened to delist the products or withdraw them for sale if the health services didn't agree to the price increases. So they offered commitments in 2019, and then earlier on this year they were accepted. And what's happened is that there will be a price reduction across Europe for these 6 medicines to, on average, below what the prices were in 2012. That's the maximum that Aspen can charge for 10 years. And the product will be guaranteed supply for 5 years. So there isn't a fine because the Aspen has committed to this behaviour. But what's interesting here is that the price reduction is backdated to October 2019, which means that affected parties and health services will obtain a rebate, and also patients who ended up co-paying for the products in certain countries, they will also obtain a rebate. So that's good news for them. And also, had the Commission proceeded to a fining decision and an infringement decision, that behaviour, the rebate, and backdating the price reduction and the rebate to patients, that wouldn't have been possible. So it seems like it's quite a good conclusion to this case, certainly for the parties who've been affected by it. Okay, I can see that time is getting on, so I'm going to talk very quickly about merger control. Every country has its own merger control regime. I'm not going to talk about merger control like this because I'm sure you know about merger control. But I will quickly flick on to this slide. So usually with merger control, it's on the basis of thresholds, like turnover thresholds. So you look at both parties' thresholds, and if turnover is met, then filing requirements will be there. And usually, in most countries, it's mandatory, so you can't complete the transaction until clearance is given. An area of particular concern in the pharma sector and tech is so-called killer acquisitions, which is probably more exciting. Sounds more exciting than it actually is, but it's where a large company, usually a large company, buys another company that a smaller company, a startup, products, pipeline products that would compete with its own, and basically it subsumes that company and either takes the target's product off the market. Usually that's what it does, or if it keeps it because it might be slightly further advanced, it doesn't matter because it's competitor and there's no incentive to compete and reduce prices. So competition authorities are becoming very concerned about these because of the effect on innovation, competition and ultimately consumers. But because usually what happens here is because the target company is small, it's a startup, their turnover doesn't hit the threshold, so there is no requirement for the transaction to be notified for clearance. An example is in relation to tech, actually. It's basically the Facebook's acquisition of WhatsApp and also Facebook's acquisition of Instagram. They didn't hit the European threshold, so they would have gone under the radar and uninvestigated, despite quite obviously they were taking competitors out of the market. So in relation to pharma specifically, a 2018 paper estimated that between 5 and 7% of pharma acquisitions are killer acquisitions. So as I said, it's taking competitors and competing products out of the market. So how are they dealing with this? So in 2016, there was a consultation on procedural and jurisdictional aspects of the merger regulation. And they considered, and the Commission considered changing the jurisdictional thresholds, making it like the UK, for example. We have a share of supply where you look at how much product the parties supply on the market as opposed to having pure turnover thresholds. They also considered looking at the value of a transaction as a guide, but ultimately they ignored these. And instead, earlier this year, they confirmed that what they're going to do is use a tool that they've already had at their disposal. And the tool is Article 22 of the merger regulations, which is a referral. So member states can request that the Commission reviews a transaction that it wouldn't otherwise have jurisdiction over because the turnover thresholds aren't met. It has to affect the trade between the member states and threaten to significantly affect competition. The Commission has clarified that this includes transactions where the merger state's own thresholds are not met, and it also includes transactions that have been completed and implemented, although they probably won't look beyond transactions that have been completed more than 6 months previously. So as far as I know, there have been no referrals to date, or if they have, they're in the process and they haven't been made public. But it's just something to keep an eye on, that there's not the degree in Europe now of certainty over merger control that there used to be. You used to know that if your transaction hit thresholds, it would be notified and then you get clearance or not, depending on the circumstances. But now that's not the case, and we enter more into UK territory where there's a clawback of potential clawback rather of transactions that might have been completed, and there's around 6 months from completion that they could be reviewed. I'm late, I can see that. So this is just something that I thought I'd touch on very briefly. Number of regulators have got together and they want to work out the best way of analysing pharma mergers, basically. And they've issued a call for information and comment. It's the FTC that's issued a call for comment from the public and economists and pharma companies for help, basically, in how to update their approach to pharma mergers. And it's almost like a best practice, global best practice.